and welcome to the debate. I'm your host, Maqbool, with you at PTV World. In today's show, we're going to be talking about two very important stories. The first is in reference to what has happened in the Supreme Court today with a historic in-camera session that was conducted with a full court bench with the new Chief Justice of Pakistan. And this is important, especially in terms of the significance it raises in terms of the in-camera session in itself, giving the public eye a view of what goes on inside the apex court, and also, of course, very important matters and behaviors of different judges that often come under question later on. And then, of course, with regards to the fact that this was a full court bench after about 8 years in the country, whereas previous requests for many cases being heard by a full court bench being denied. And then, of course, what was being discussed in itself, the very important, the Supreme Court procedures bill, which is something, of course, that is of paramount importance, not just in terms of the way that different benches were formed previously under the previous CJP, but also in terms of the overall view that the judiciary is going to be taking with reference to the powers of the CJP and whether or not it's going to move ahead with something that curtails the CJP's powers, but perhaps enhances that of the apex court, something that was also part of the discussion. The Chief Justice of Pakistan, of course, has said that since the matter is still pending and the hearing has been adjourned till October 3rd, since then he has taken the consultation of two more senior judges and himself as part of the three-member committee that is going to be taking a look at the formation of benches, as of course proposed by the parliament as well. Under the act that was, of course, under discussion. A number of interesting arguments as per the hearing are also something that we're going to be exploring further, in not just in terms of what was discussed, but in terms of the way that it points towards the jurisdictions of both the judiciary and the parliament, and then what really is the matter that was under discussion at the moment and what sort of aspects are going to be taken into account. So a lot to try and understand and unfold here in terms of what happened at the Supreme Court and whether or not we're going to move ahead in the direction that seemed to be set by the Chief Justice of Pakistan today. Our next segment is going to be taking a look at the engagements that the caretaker Prime Minister will be having as part of the UN General Assembly and its sidelines. And this is going to be the first caretaker PM who's going to be taking part in these engagements. And we also know that, of course, the UNGA and his keynote address is one aspect. And then with reference to what is going to be spoken about regarding SDGs and the development and work of Pakistan in this regard is something that is also going to be undertaken, as well as financing with reference to the private sector in terms of development of the country and other projects to be undertaken. So this is something that we're going to be exploring in the show today and discuss more. And as always, of course, I've been joined by senior analysts Farrukh, Pitafi and Faisal. I've also been joined online by Mr. Shabbir, Advocate Supreme Court, and Barrister Asad Rahim, who's the legal expert and political analyst as well. Thank you very much, gentlemen, for being part of the debate. And let me start with you, Barrister. With reference to what is going on, there is, of course, a lot of discussion previously also held in terms of what the Supreme Court is going to be talking about and the kind of decisions that are needed to enhance the role of the judiciary and, of course, the role that the new Chief Justice of Pakistan will be taking in. What do you think of this very bold first step forward by the Chief Justice of Pakistan, something that he had been a proponent of previously as well, especially in terms of the independence of judiciary and the contribution do you think that the in-camera session is going to make in this regard? And then, of course, the fact that the decision was also taken that a full court bench hears the matter.
Well, thank you so much. An in-camera session would imply that this is a private session because the Supreme Court has decided to televise the proceedings and make them public. You're absolutely right. That is unprecedented. And people are praising it for its increased transparency. But there are a few other aspects that do require consideration. The first being that this is not the political arena. This is a superior court. These are not politicians. These are litigants and judges. And when you do bring cameras into the judicial forum, that tends to incentivize a very different kind of litigation. That tends to incentivize being performative. We saw today also that very many judges were expounding their individual judicial philosophies rather than actually asking the lawyer what his perspective was or what the legal position should have been. Some were speaking perhaps more than they usually would. So when we decide to open up the Supreme Court forum to the television cameras, that's something very different from saying that we are adding to its transparency. Courts are public fora and they are open to the citizen. The citizen can walk in, the citizen can view the proceedings. When you decide to live stream it and decide to make it the subject of 24-hour news coverage, then I feel, and I say this with regret, that you are incentivizing a very, very performative aspect where people will get on their soapboxes. It did not do much to even clarify what the judicial proceedings were. In fact, more and more people are mystified by what technical points were under consideration and why the lawyers were not being made a larger part of the proceeding. So where people are praising it for transparency, I would reiterate that this has opened up other dimensions that really, really require further thought.
All right, and that's an interesting point to take. And Mr. Shabbir, I'll take your opinion on that matter as well, and whether or not the benefits that possibly exist of an in-camera session are outweighing the kind of aspects that Barrister Asad was pointing out.
You see, I partly agree with him and partly I don't agree with him. But for different reasons. I for one would advocate not just one hearing, but every hearing of every court, not just the Supreme Court, to be holding an in-camera session. On your other program earlier on, I was pointing out to the benefits, because you see, the judges start coming on time. A lot of other factors could be avoided if there are in-camera sessions. But for a moment, agreeing to my learned brother, what did happen today, and I was to point out that, you see, we saw some outclass advocacy. We saw today brilliant arguments which were made, and the preparation seemed outstanding. The only unusual part was that this time the advocacy was being done by the bench and by not the learned advocates standing at the podium. Now, this is unfortunate, but we need to realize that this was for the first time that an in-camera session was being conducted before any court in Pakistan. So maybe with the passage of time, we would learn to, when it becomes a norm, to not play to the gallery, to make ourselves used to of in-camera sessions.
Right, absolutely. When we take a look at, of course, the impact that this has created, Farrukh, I'd like to take your perspective in as well, because, of course, there is the aspect that it's the way that it affects the hearing in itself. But then I want your opinion also in the way that it was covered or discussed or analyzed by the media, and the way that it was absorbed and understood and taken by the public.
Right, Sana, thank you very much for the opportunity. I think I was listening to Asad. Asad is a dear friend, but I was a little bit astonished by the argument that somehow live coverage is going to enhance or increase the performative aspect of judiciary. I don't get this. If I shut my eyes, will you stop performing? Right? Right now, what is happening is that the people of Pakistan actually pay taxes, and we have actually laid down a constitution and a system. There you have judiciary. In India and almost all over the world, this is the new trend, that you can live stream whatever is going on in the court, and that actually enhances the punctuality, the quality of arguments in the court as well, and people are there to understand what exactly is going on in such a high forum. My only concern was because everything was done in a quick fashion. I think that I could do with more cameras, or cameras that were placed in very different manner. I think that eventually, when it is going to become a matter of routine, you're going to have cameras that can actually be embedded into the rostrums, and from there or in front of them you can see a better image or image quality that might be available online. Now the important thing is that a lot of people of the country, a lot of lawyers cannot come to Islamabad to hear in person what is going on in the Supreme Court of Pakistan, particularly room number 1, but they can actually learn a lot from the arguments that are being made there, right? If you can actually collect all these footages and then archive them online, it can actually become a humongous support for case law study all over the country. So I think that what happened today, hats off to the this Chief Justice of Pakistan, hats off to the Supreme Court of Pakistan. I think that whatever happened today was quite amazing. There is always this concern, because I thought that there were two strands of thought that were being expressed. On one side, of course, the CJ and others who have been very supportive of this law in the past, they were speaking, and there were those who have actually, two judges who have actually given some verdict in the past or stayed the law. So we saw that there was a little bit of defensiveness, but eventually it will pass and you will have better quality of arguments, and it can educate all of us. So I really applaud the decision of Supreme Court, both the full court and the live coverage. Sana, over to you.
All right, so then let me take your opinion in this as well, with reference to what has happened. There's also, of course, a discussion we had earlier of the way that the person of the Chief Justice of Pakistan and the way that is going to influence any decision. And it seems that, of course, right after he's taken control of the office, this is something that he has taken a step which is historic, whether or not we, of course, move forward with any perspective of its pros and cons. But I want your perspective then in terms of the contribution or the direction that seems to be taken by the Chief Justice of Pakistan, and whether the in-camera session and the full court bench are decisions that say more than just the decision in itself, that they are also symbolic in the way that the judiciary is being viewed at the moment.
Who should answer this, Sana?
Faisal?
Faisal or Farrukh?
Faisal. Faisal.
Yeah.
I thought that it was a counter question.
Thank you.
Go ahead.
Yeah, Sana, overall, if I, I do consider it a brilliant idea to obviously, make it transparent for public at large. But I actually came across with different views. I met with quite a few people, and everyone I was, talking about it, they gave their own perspective, and one of them perspectives was a very interesting one, and that one was related to that the 95 to 99% of the proceedings, they would be conducted in English language, whereas obviously English is not a widely spoken language in Pakistan, so the masses at large, they would not be understanding the proceedings anyway. If we talk about of course the journalists, of course the lawyers, of course the ex-judges and bureaucracy and other institutions, of course they would be taking the points out of it, but people at large, they would be ignorant about whatever is going on in terms of proceedings and in terms of the law and whatever the judicial brawl is going on inside the courts. This aspect is quite interesting one and quite important one. In coming days, we might see that Urdu as a language, it gets adopted so that the masses at large can understand it. But overall, I have a very positive view about it, that these kind of steps, they actually strengthen further the judicial practices of a country. We know that the Western world, they already do it and they successfully do it. I agree with Farrukh when he highlights the point about the production. The better production is required, because it would even make it more transparent, because in law and in the practice, of course, the gestures and the face expressions, they matter a lot, and I think they should be caught as well while productions are done. And overall, few of the comments which were made by people I was talking to, they said the most wanted cases in terms of the political importance, or cases that are related to different corruption cases and different, they should be the ones who should be highlighted on the priority basis. Reason being, people at large, they do want to see the transparency when it comes to our political fabric. Sana?
Right. Right, absolutely. Let us also take a look at the kind of arguments that were discussed, and of course the act of the parliament that was also under consideration. Barrister Asad, there were a number of arguments and aspects that were discussed, and I want to understand what is at the core of what is being discussed at the moment, because a lot of times within this hearing there was discussions of the jurisdictions of the parliament and the judiciary, what the parliament can or cannot do, how it's affecting the independence of the judiciary, and whether, irrespective of what the parliament has said, or whether or not this is something that the parliament can or cannot do, it is in the benefit of the judiciary and its independence that the powers are not retained within a single individual within the apex court. And then I want to understand then, at the core of this hearing, what is it that this bench is actually looking into?
So right before answering your question, I would just want to take up Farrukh Saab's, I think he used the word astonishment, and may I add that I agree with many things that my learned senior at the bar, Shabbir Saab, said. But to come to what Faisal Saab said and what Farrukh Saab said, if you are going to open this up to the world, as one says, again, this is something that is a public forum. The public does have access. Our entire conversation has revolved around picture quality, around facial expressions, and not so much on actual jurisprudence being discussed. There is an innate tendency for human beings in front of the camera screen, no doubt all of us are doing it right now, to perform, to play to a gallery, and if a verdict is not going in a particular direction, then to just stand on one's soapbox and give speeches about one's own individual judicial philosophy. And I wouldn't want to get into any contempt proceedings, so I won't say whether that happened today or that didn't happen today.
Let me actually explore this a bit further, and I want to understand. I understand your point and perspective, but I want to also explore then that perhaps the scale of what you're talking about, the impact and the number of people it will influence, has definitely increased through an in-camera session. But there are the people who are sitting within the courts. There are, of course.
The entire proceeding is being conducted in English, so you're not getting through anyway. You're discussing incredibly technical, incredibly arcane legal points for which the average citizen, when he sees it broadcasted on a normal mainstream channel, is not cognizant. It is the job of the Supreme Court to make him cognizant by making your judgments in the Urdu language and by focusing on jurisprudence rather than on judges engaging in a debate within themselves, rather than engaging the litigant public and asking him what the question is. Taken to its logical evolution, we should just put up one of those Instagram reaction bars on the side so that people can put in hearts and smileys and send in comments also. So this is different. It is a Supreme Court. It does have its own status in this country, and not everything requires excessive digitization. But anyway, so to come to your actual question, the Supreme Court Practice and Procedure Act is a law passed by the outgoing PDM government, in which they have attempted to narrow or rather remove the Chief Justice's suo motu power by extending it to 2 other judges. So there will be 3 judges in a committee who will decide amongst themselves by majority whether a case should be taken up under Article 184.3, pending them deciding its procedure. They have also said in the bill that any cases that fall under 184.3 that have been decided will also be able to have an appellate forum. So you will be able to appeal judgments that have been decided under Article 184.3, the argument being that such cases did not have the right to appeal. Thirdly, they also say that if a case is of constitutional significance, then 5 judges should hear it. Now, to come to your last question, Sana, in terms of what is happening, one of the arguments that is being advanced on the other side is the suo motu power is actually the essence of the Supreme Court's judicial power. It is not procedure. And there are Supreme Court judgments on this point also. So to actually say that you want to graft a fresh jurisdiction on top of the existing Supreme Courts, you will have to amend the Constitution. So that's one question that is being taken up. Another question that Justice Aisha Malik Sahiba advanced is that if a full court takes up a case and you are giving them the right to appeal, well, then which judges are going to sit in that appeal, because all judges have already decided. So this law has very many issues, and the crux of it seems to be that you are declawing the Chief Justice's power and committeeizing it.
Right. The Chief Justice of Pakistan also remarked of the fact that he does not wish to have the kind of authority that perhaps the previous Chief Justices also enjoy, being able to take so more action or have a certain stance on cases of huge significance. He also quoted one case in the hearing. And I want to understand, Mr. Shabbir, then, that this is something that previously, of course, has happened and historically has been the power of the Chief Justice of Pakistan, both in terms of bench selection and then so motor as well. And it seems that what the Chief Justice of Pakistan now is inclining towards is the constitution of the committee. Is it then not something that then when we look at what the essence of the judiciary has been previously, is that not something then that is just being diluted from a single individual to a bench of 3 members, including the Chief Justice? Or is it actually sort of harming the essence, irrespective of whether it's now with 3 individuals or 1?
You see, if you ask me, the Honorable Chief Justice seemed to be winning the public battle also, because he was throughout acting selflessly. You have to put these things in the context. If you were to see the previous Honorable Chief Justice, as he then was, Honorable Chief Justice Umar Ata Bandial Sahab, this bill, on the face of it, attempts to do 2 things. Number one, it attempts to structure the discretion of the Honorable Chief Justice and attempt to dilute his powers, that such powers should not vest exclusively in one man. Now, the previous Honorable Chief Justice constituted an 8-member bench, and the 8-member bench unanimously suspended the operation of the bill before it was even converted to an act. Quite conversely, if you see what the incumbent Honorable Chief Justice has done, the very first thing he takes up is the very same bill, and he constitutes a full court. So I would give 10 out of 10 marks for constitution of full court, number one. Number two, and throughout the hearing, he kept on insisting and arguing as to why the Honorable Chief Justice or a single man should not have these powers all to himself alone. So he seemed to be arguing against his own powers. So I think give it to him that throughout he acted selflessly. And if I may shed some light on the bill itself, on the act, you see, like my learned brother Asad pointed out, the crux of the act, which is twofold. So far, and for your audience, I would make it in very baby terms. The Supreme Court is the ultimate court and is an appellate court. Mostly and traditionally, it is the court of last resort. But only one unusual power is given, which is its original jurisdiction by the Constitution. So in the past, whenever the exercise of power under Article 143 was exercised, it was criticized because you never had right of appeal. So the case can start in one day and tomorrow it can finish without giving anyone any right of appeal. Now, it is, you would see previously that Prime Minister Nawaz Sharif was disqualified back then, and so many dozens of parliamentarians were justified under the exercise of 183 powers. So the exercise of
Right,
powers under
absolutely. Mr. Shabbir, I'm unable to hear you, so I'd take this to Farrukh since I'm not able to hear Mr. Shabbir at the moment. With reference to the impact that this also has on the different role that the institutions, of course, have played previously in terms of how the previous government and the Prime Minister also got pitted against the previous Chief Justice of Pakistan. I want to understand then, Farrukh, whether or not the kind of discussions that we've seen within this hearing as part of the jurisdictions of both the judiciary and the parliament, is that still something that needs to be considered, irrespective of whether what the parliament has suggested is in fact something that helps with the independence of judiciary?
Right, Sarah, I think that it is a legitimate question. Frankly, that's why we were all listening to whatever was going on in the Supreme Court of Pakistan, because when it comes to independence of judiciary, there are concerns regarding that as well. And then also remember that the Chief Justice of Pakistan also brought up the matter of pendency in the court, and how Article 183 184.3 actually curtails that and somehow keeps on adding to the burden. Right. So at this moment, whatever is being discussed, of course, it is a legitimate issue. And I hope that in the next hearing or in a couple of hearings, we are going to get to the bottom of the matter, because then again, as was pointed out, Justice Aisha also mentioned that if you are going to actually create a full court at the end of the whole process, what exactly is going to happen, whether it is going to add to the pendency or whether it is going to lower the number of pendency. So these are important questions, Sana. And these questions, that's why we kept on arguing that the full bench actually hears this, because it is appellate court, and if it actually takes cognizance of something on original, jurisdiction basis, once it has actually delivered a decision, then you don't have any kind of right of appeal anywhere, right? That becomes a difficult issue. So finally, we are seeing that these issues are being discussed in front of us, and they are being discussed by the full court. So we are going to actually understand all the merits. Now I wanted to actually address the issue of English as well. Amazing, we are sitting here talking in English. This is state channel. We keep on, Asad, I, Faisal, everyone keeps on writing in English as well. And then we are going to say that people of Pakistan, none of them actually understands English. I mean, come on, the best way to actually live stream of all of this, and I understand accessibility is going to be an issue. And once you have created an app, I don't care about television channels, if you are live streaming this on app, then what you can do is, when Prime Minister speak, usually there is an accessibility argument there as well. People are presenting the same case in sign language. So why can't we have an additional soundtrack where somebody can translate in real time what exactly is being said? So this argument that all of this should go away because people tend to grandstand, and secondly, people are not going to understand it in any case. That doesn't make sense to me. I think, excuse me, my throat is bad today. But regarding all of this, if you want to educate people, add to the solution, not to the problem. And that is by airing more information rather than keeping it from people. Sana.
Sana. Sana, go ahead.
I think there seems to be some problem with the audio with Sana. Faisal, you go ahead.
Yeah, I'll start. Obviously, if I look at this issue, I think it is a good step forward. At least people are coming to terms with it. That the procedure of the courts, of course, it would be apparent to the people how it is being followed and how the different benches they are obviously get constituted. But one important thing which needs to be highlighted everywhere, and that is of legislation. I mean, courts are there and judges are there just to interpret the law. The law itself, the constitution itself, it is being crafted, legislated, of course, in the legislature assembly, and that is our National Assembly. And the importance of National Assembly in a democracy, nobody can snatch that. And obviously the laws which are made there, they are the ones that are going to be interpreted in the Supreme Court.
Right.
And when we
Faisal, I wanted to ask a follow-up question regarding what you are saying and what others were saying. This bit about grandstanding, if it is there, don't you think that even television tickers that go on can have that kind of impact that people tend to actually, we remember former Chief Justices, particularly Iftikhar Chaudhry and Saqib Nisar, there was a lot of grandstanding, particularly through tickers. Don't you think that that could also happen? And if today, for example, some Prime Minister and President go and sit there listening to what is being said in the court, there could be grandstanding even there.
Yeah, you're very right about it, Farrukh, and especially, of course, we have precedents set by the few of the previous, Chief Justices, in which, of course, we know that so motos were taken on each and every day, even when there was, inflation related to tomatoes. Of course, we saw there was a suo moto which was taken, and
Lahore High Court actually took a suo moto on dengue machhar.
Dengue machhar as well, and what I'm trying to say is, obviously, center stage is something which there are precedents that it was required by few of the personalities in the past, but now I think everything would be in front of the people. The capabilities of the judges and the law being followed and the interpretation which are coming out, of course, it would be quite interesting to see in the coming days.
And I think Sana is back with us.
Yes,
Sana, over to you.
Yes, I'm back, and thank you so much for taking cover while I couldn't hear you. But I believe the guests are also with us, so I'll go back to Barrister Asad with reference to an important aspect that was discussed is whether or not, of course, the issues of public importance and the violation of fundamental rights exist or not. And I want to then understand whether or not, when we talk about arguments such as how this is perhaps limited to a certain institution or an office, or the fact that there isn't a serious violation of fundamental rights, since this is just adding to the independence of the judiciary. How do you see these arguments in terms of the way that they're going to impact particularly this case, and then whether or not the discussion of the powers of the Chief Justice and of course with reference to the Act, the Apex Court as well, are also something that then need to be extended perhaps later, or can be viewed in a broader context of towards cases which are beyond a political or fundamental importance?
Well, we have seen a sea change over the last 20 years in terms of the Supreme Court expanding its jurisdiction as far as fundamental rights are concerned. They also have created a human rights cell, which we saw was catalyzed greatly under Justice Iftikhar Chaudhry, though its antecedents go back to Justice Afzal Zalla and before. In terms of the arguments whether fundamental rights are affected, because the matter is sub judice, I'd rather not get into whether one argument will determine the course of these proceedings over the other. It is a question that has been taken up and asked of the petitioners, that if you do want this law struck down, then the natural argument is, well, which fundamental rights are infringed? And we saw some of that argument today. But not to keep belaboring the same points, but to what Farrukh Saab, Faisal Saab just mentioned, tickers and live broadcast are two very, very different things. If there is a patient who is suffering from a drug overdose, the cure is not to inject him with more of the same drug. The solution to grandstanding is not more grandstanding. It is to focus on jurisprudence, and far be it from me that I say that the citizens' constitutional knowledge and awareness of Supreme Court proceedings should ever be curtailed. the argument was very different. The argument was that Justice Jawad Khwaja has put in a judgment from 2015 onwards that all proceedings have to be in Urdu, including judgments. That has not happened, and the main onus remains on the Supreme Court. Now, that may translate poorly for our system of English medium lawyers and judges, but the advantages that will accrue to the average litigant are enormous. And I think that really brings me to the second thing. Jurisprudence is something that is shown in judgments. That's why we keep saying again and again and again that judges speak through their judgments. Judges do not speak through PTV World live stream. And that tended to have a chilling effect on what was discussed. So even this time, and I promise I'll say this the last time, our judges were expounding their individual judicial philosophy rather than advancing the crux of the case, which is a petitioner is saying one thing and the respondent, the federation on the other side, is saying another. Instead, we had the judges in a debate between themselves, and they were using the lawyer at the rostrum as a proxy to ask these questions of each other, which, to my very modest mind, does not really advance the cause of the case that is being pleaded. In terms of constitutional literacy, judicial awareness,
all right, Barrister
that
Asad,
happens through
right.
actually making these proceedings.
Your point is taken. We understand.
That used to happen in the past as well.
Right. Let me quickly also go to Mr. Shabbir, since we're almost short of time for this segment. There is also, of course, as part of the discussion, many references given to previous presidents or previous court proceedings. And the Chief Justice also spoke about how the Constitution is something that holds paramount importance in light of any of the precedents. And I understand that. But I want to also understand, is it not something of importance or significance as to what has happened previously in courts, or what sort of precedents exist, or the way that the judiciary has exercised its powers previously, that is also relevant to the discussion today?
Is that a question posed to me? Okay.
Yes.
You see, today was an eye-opener, in the sense that what seemed pretty unusual to everybody, this is a standard day in the Supreme Court. And I've been witnessing for the past and practicing for the past 4 years or 5, for that matter, it was a full court, but even if it is a 5-member bench, we witnessed QFI proceedings. It lasted for more than 1 year and a half. The NAP proceedings, in almost every proceeding, this is a standard case wherein question is asked by one learned judge and the answer in the shape of a question is given by another learned judge. So what happened today was not unusual, but an eye-opener. Now, what is extremely important is, and I must tell you through your channel, that there is one provision in the impugned bill, which is that urgent applications are to be fixed for hearing within a period of 14 days. I'm a fan of this clause, because so many lawyers, there would be any lawyer which would be aggrieved by this insertion. So many other lawyers have filed urgent applications. They've been pending for over 1 year. They are never taken up. So the ordinary litigants, they are already suffering, whilst the bulk of time is taken by these 184.3 proceedings, by these proceedings which are labeled as proceedings of public importance, when in fact, who is suffering is the ordinary litigant. People's home have been encroached upon. People are in the jail, and many people may have even died. Their matters are not even fixed. So I think this is something that we need to look at. And this is one of a good provision in the impugned bill, which needs to be enforced. Before I take your further time, need to point out two things very important. You see, there are two core questions before the Honorable Supreme Court, and which were not really being discussed. One is whether the impugned act amounts to enlargement, whether when you give a right of appeal, whether giving the right of appeal amounts to enlargement of the powers of the Supreme Court. Number one. Number two, with the same point, whether this amendment can be introduced through an ordinary act or through a constitutional amendment. These are the only two questions which require to be answered. But perhaps it took us so long to even frame questions. One of the learned judges, Justice Muhammad Ali Mazhar, sarcastically commented in the beginning of the hearing that we are 105 questions down. That was the first 1 hour, and lately there were 1,000 questions.
Right. Thank you very much for that. And thank you, Mr. Shabbir Ahmed Shah, for joining us. Thank you, Barrister Asad Rahim, for being part of the debate as well. And of course, it still remains to be seen as to how the hearing is going to proceed on October 3rd and what is going to happen. But for now, of course, important discussions are being held, and at least there is a lot to think about. The right step forward, both for the judiciary and the parliament. We're going to also quickly take a look at the Prime Minister's visit to the UN General Assembly and his upcoming engagements. As part of the UNGA visit, of course, he's also going to be engaging on the SDG summit, talking about what Pakistan has been doing. And Faisal, I'd like to take your perspective on with reference to the kind of important aspects that this is going to have, particularly also for the caretaker Prime Minister that is going to be representing Pakistan and is going to put forward a direction, especially in the very difficult times that the country is going through, both politically and economically. It's going to be a very important platform to set the tone for how the world views Pakistan.
Yes, and if we look at obviously his first visit to US right now, of course, and obviously UNGA, he's going to address on 22nd of September. And we so far know that he will be attending one of the conferences as well that is related to climate change, and he would be speaking and highlighting obviously last year's havoc which was made by the floods, last year's floods in Pakistan, and what kind of help was extended to Pakistan, especially Pakistan being one of the worst hurt countries when it comes to climate change. He will be highlighting that, and of course international issues, he will be touching them as well. Most probably he will be talking about the peaceful resolution of Ukraine as well, because it is badly affecting the third world countries and underdeveloped countries, because they are facing the food shortages, grain shortages. He will be highlighting that as well, and most importantly he will be highlighting internal and external security related issues which are being faced by Pakistan right now. I'm talking about, of course, Afghanistan, as well as, of course, whatever is happening in Indian illegally occupied Kashmir. He will be highlighting that as well. But right now, of course, Pakistan is facing obviously threats from the western border as well, reason being TTP, BLA, all of these banned outfits, all of these terrorist outfits, they are active again against Pakistan once more. So he will be highlighting that as well, and he will be reiterating the fact that for the world, the war on terror might be over, but here we are still fighting it out. And of course, we will be seeking support from the other countries as well.
Right. Farrukh, when we take a look at the UN General Assembly session as a platform also, and with a number of important engagements, as Faisal has pointed out, including climate change, SDGs, and also financing by the private sector towards development and the security issues as well. I want to then understand what sort of opportunity does this platform give to Pakistan at this moment in terms of presenting our case and the possible hope that we have as an outcome from this, and whether or not the bilateral engagements that the PM will also be having on the sidelines of the UN General Assembly will hold more importance, perhaps.
Right, Sana, and these are important questions. Let me start by actually highlighting a very interesting fact. There have been many prime ministers and foreign ministers who have actually spoken at UNGA. But to my knowledge, this is the first caretaker prime minister who is going to address the UNGA. Out of the 195 members, 145 are being represented by either the head of states or head of governments there, right? It is an annual event where, the basic body of UN actually meets, and all countries actually compare notes and highlight their particular concerns as well. So what Pakistan has been doing is repeatedly actually, and of course there's another very important context here as well, sustainable development goals, Sana. The time set for it is halfway through. So it is important for all the countries to actually compare notes regarding that as well. So what Pakistan can do and will do is actually chalk out or present its own journey, its own experiences, what were the the things that were learned and how the other countries can benefit from that. Having said that, after that, of course, the climate change issue, particularly the experiences of last 2 years, they have been actually devastating as well. So it becomes very important that Pakistan actually highlights that too. And the Prime Minister then, of course, is going to, flag the human rights abuses in Indian occupied Kashmir, and similarly what is happening in Afghanistan as well. On the sidelines, of course, he will get the opportunity to meet many leaders, and then he is going to go to a think tank as well. But I think that with all of this, remember he is a caretaker Prime Minister, so there is a very limited window that he can exploit, but he is exploiting it. Over to you, Sana.
Sana.
Excuse me.
All right. Thank you very much, Farrukh, and thank you, Faisal, for joining us in the debate, of course, as always, and for sharing your views. And of course, there's going to be a lot of important issues that we're going to be discussing throughout the week, with, of course, a lot of focus on what is going on within Pakistan as well, within the courts, and, of course, the political dynamics too. But what is of concern here is, of course, that we're able to look at it from all angles and try to analyze what is going on and bring to you all kinds of perspective at the debate. So keep watching PTV World, and we'll now join you tomorrow.